Good evening and welcome to Kansas Appleseed's program, Justice for All, the Future of Kansas Courts. I'm Jamie Reaver. I'm the Executive Director of Kansas Appleseed. Before we launch into the program, I wanted to take just a few minutes to tell you a little bit about the work that we do at our organization. We are a public policy and advocacy organization dedicated to the belief that all Kansans should live in thriving, just, and inclusive communities. Our small but mighty staff of 12 works to advocates for better laws and policies at all levels of government. So here are some of the things that we work on. We're working to end hunger by increasing access to food assistance programs. We're working to improve the state's foster care system so that it doesn't traumatize the kids it's meant to protect. We're working to increase civic engagement in communities across the state because we know that communities that vote are healthier. And finally, the reason we're all here tonight, we want all Kansans to benefit from fair and effective systems of justice. We are about 7 weeks away from the August primary, and as usual, there's a lot at stake on this year's ballot. Just as Kansas for us to do nearly 70 years ago, we will be voting on how Kansas Supreme Court justices are chosen. And I can't think of a better panel to help us understand this process. Tonight's program will include a panel discussion moderated by Sherman Smith, the editor-in-chief of the Kansas Reflector. Their discussion will last about 1 hour, and then you'll have an opportunity to ask questions. And now on to our program. It is my pleasure to introduce our panelists. Carol Beier was appointed to the Kansas Supreme Court in 2003 by Governor Kathleen Sebelius, where she served until her retirement in September 2020. She previously served for more than 3 years on the Kansas Court of Appeals. Before her time on the bench, she practiced at Folsom & Seapigan in Wichita and at Aaron Fox in Washington, D.C., and worked as a Georgetown Law Fellow at the National Women's Law Center and as a law clerk for Judge James K. Logan at the 10th Circuit Court of Appeals. Jay Fowler is a partner at Folsom & Seapigan and has built an extensive and highly respected civil litigation practice in state and federal courts. Mr. Fowler is a fellow at the American College of Trial Lawyers, the Kansas Bar Foundation, and a former fellow at the International Academy of Trial Lawyers. He enjoys Martindale-Hubbell Law Directory's highest AE ratings for lawyers, and for many years has been listed in Chambers USA as a leading commercial litigation lawyer in the United States. Mr. Fowler is a former elected member of the Kansas Supreme Court Nominating Commission. Brandon Johnson is a Wichita native who served 2 terms on the Wichita City Council, representing District 1 from January 2018 through early January 2026. A longtime community advocate, he previously founded the nonprofit CORE, Community Operations Recovery Empowerment, to focus on youth employment, neighborhood development, and ending gang violence. I am now pleased to turn the program over to Sherman Smith.
Very good. Thank you, Jamie and Kansas Appleseed, for putting this event together, and to our panelists for being here. Thank you all for being here, for giving up a weekday night to learn about this. I want to start our conversation here by just getting the panelists' point of view about what's at stake in the August election. So I'll start with you, Justice Beier. What is at stake with this vote?
Great. Good evening, everyone. Thank you for coming. It's a pleasure to be here with you. I think there are a lot of serious matters at stake on August 4th. I think the quality of the folks who are going to serve you as Kansas Supreme Court justices is at risk. And I think the level of integrity I think most of us have come to count on in our justices is also at risk. And I don't mean for tomorrow or 5 years from now or 10 years from now, but potentially for generations. The system we have now is exactly the same age I am. It's going to be 68 soon. And it's worked pretty well overall. I think we're going to talk a little bit about its genesis in a minute, but I think it's been working, and as one of my former colleagues says, if it ain't broke, don't fix it.
How about you, Councilman Johnson?
Yeah, good evening, everyone. Honored to be asked to be here and be with you all this evening. I would say ditto. To me, what's at risk is just justice in Kansas in general. When you look at, and I was one of these folks, but the people who run for office don't always have your best interests at heart. And sometimes when you have money in politics, that money is for one specific purpose. And I've seen all throughout social media, there's different motivations for folks to try to change this process, and that's to get the outcome that they want, not to follow the law. So I think if you care about justice and following the law, the state constitution, this is really important. And what's at stake is if the process changes, you may not see that. And ultimately, it will impact you at some point, and for generations to come. And that's hard to overcome. And especially in the state legislature where things move really slow, you don't always see progress in the ways that you want. So if this process changes and then it's now we got to change all these laws to try to make sure that Supreme Court justices will follow that, there'll be a question if they will. And then two, what does that look like? How much effort are you putting in to go through that whole process again? It's hard enough now. So to me, what's at stake is justice for all. And what will that look like in the future if this process changes?
Very good. I think we'll dive into more of these themes as the conversation goes on. But Mr. Fowler, what are your thoughts?
Well, I agree that integrity is a key component of what we're going to be dealing with on this amendment. I'm a rule of law guy, and what that means is that you have a set of rules and processes by which you decide cases, and you do it in a fair and impartial manner. And then the judge makes a decision, or the justices make a decision, and they write an opinion, and they explain their opinion with the reasoning that allows people to understand the result. And when you do that, you build the credibility of the judicial system. And I think we've done a pretty good job here in Kansas. What this proposed amendment potentially does is allow parties to change the judge to get a different decision. And if you change the judge because you think that judge will vote for you, then you're missing the point on the rule of law. And that's why this is critically important here. We'll get into it more as we have discussions, but a partisan election system for a Supreme Court justice would probably require $1 million, maybe more. Who's going to pay that? The person or interests that are going to pay it are people who want a specific outcome, and they want the person to get that outcome. And that means you're setting aside the rule of law. So that's why I say integrity is important, and I think that's what this is about.
You know, the proponents of this amendment would say that the thing that's at stake is the public's ability to have a bigger voice in who gets on the court. Do any of you want to address that point?
I'm happy to. Sure. You're saying the proponents say that?
Yes.
Yeah, they've got a pretty easy, I would say, facile argument. Just, more voting. Voting is good. We all like voting. It sounds benign. But I think we need to be a little bit more sophisticated when we hear that, and a little bit more skeptical. First of all, our current system has voting as a component of it. Our current system is not purely gubernatorial appointment. It's not purely driven by the nominating commission. Those are pieces of it, and we're going to talk about that in more length. But the nominating commission does its job, the governor does his or her job in making the appointment. But as soon as that justice who's appointed has served for 1 year on the court, that justice must stand for a retention election. And all of you get to decide whether that person stays on the bench. So we already have a voting component in our system.
It's also every 6 years after that first retention vote.
Exactly. Every 6 years for the Kansas Supreme Court, they must sit again for retention. 4 years for the Court of Appeals, 4 years for your district judges. But the public gets to weigh in on a regular basis on whether these folks keep their jobs.
If memory serves, you were the subject of a campaign to try to get you off of the court.
Yes, I was. Somebody asked me at one of these events not too long ago if I could remember when retention elections became somewhat more exciting, shall we say? And I said, actually, I can. It was January 22nd, 2010, about noon. I was sitting at my desk in Topeka, eating my lunch, because that's what working mothers do, because then they get home earlier. And I was sitting there eating my lunch, kind of minding my own business, probably working on some case while I was eating it. And I heard, "Fire Beier, fire Beier," being chanted outside the Judicial Center. And it was folks who had a particular point of view on an issue. I happened to have been the member of the court who had written a couple of opinions dealing with that issue, specifically with the behavior of one of our former attorney generals, Phil Klein. I didn't write for myself. I wrote for the court, but my name was on the opinion, and my name rhymed with fire. So in 2010, I was subject to one of the first more hotly contested retention elections in the state.
But you prevailed, right? What was the vote
I did
in that?
prevail. I did prevail.
Do you remember the margin?
It was lower than ordinary. When I first went to the Court of Appeals and then eventually arrived at the Supreme Court, my first two retention elections, so the first two, my one at the Court of Appeals after I'd been on for a year and my one at the Supreme Court after I'd been on a year, were pretty sleepy affairs. And it was customary back then for justices and judges on the Court of Appeals to be retained by wide margins.
Like 80-20 or so.
Yeah, 80-20 or 75. I mean, high margins. You could go to bed early. It was not a problem. And anyway, so 2010 changed things. And 2016 was even more that way, because then there were 5 of the 7 justices on the ballot that year for retention. As the same colleague who says, if it ain't broke, don't fix it, he said it was a target-rich environment. He's a hunter. So anyway, 2016 was even more exciting, and 2022, although after my retirement, was also exciting because there were 6 of 7 justices on the ballot that year. So retention elections are real contests now. They're real contests. People who are in favor of the retention of the justices have an opportunity to persuade their fellow citizens, as do the folks who would like to put them to pasture. They're real elections, and people have a lot more information than they once did about how to vote.
Well, I think if the crowd can suffer a little history lesson here, I'd like to give folks an idea of like how we got to this point. You said it was 68 years ago. I think I'll go ahead and round that up to 70 since you say it aligns with your age.
That's okay. That's okay about the
So
retention.
give us, there's a
There.
political scandal in Kansas history known as the Triple Play. What was that? How did we get here?
What happened? Well, back in the mid-50s, a little bit before I was born, we had a governor who lost the primary to have another term. And so he knew that he was going to be a lame duck very soon. And ultimately, his fear that the opponent from the other party would prevail in the general election it came to pass. So he was going to lose his seat in the governor's chair, but he was also going to be succeeded by the candidate from the other party. He wasn't very happy about that. And at the time, there was one of the Supreme Court justices who was, getting older, getting a little bit sick, really about ready to retire. And they were old friends and political allies. And these were in the days of elections of our Supreme Court justices. But if there was a vacancy during a term, the governor could appoint. So what ended up happening was the justice who had been wanting to retire did so on December 31st. And 3 days later, the sitting governor, who had 11 days left on his term, also resigned. And immediately they brought the lieutenant governor, actually from the hospital in Newton, to come back to Topeka. And one of his very few official acts in those 11 days was to appoint the outgoing governor, the new Supreme Court justice. And Kansans didn't like it. I mean, we don't like that stuff. We don't like skullduggery and cronyism. We like good government. And that triple play created quite a scandal. And within a couple of years, Kansans voted 60% to alter the Constitution to go from partisan elections to our current merit selection system. So it's been in place ever since.
This was a real backroom deal that happened to decide who was going to be on the court. And, we see ads now that say Kansans for 100 years elected Supreme Court justices. We should go back to that. This is why we have the system we have, right? We'll go over to Jay to tell us what that system is actually that Kansas voters put in place.
Well, we have the Supreme Court Nominating Commission, and I was on that commission from 2009 to 2017 as the 4th Congressional District representative from the lawyers. And it's a 9-member commission. It's made up of 5 lawyers, and that's a point of criticism that I'll talk about, and 4 lay people. The lay people are appointed by the governor. And we have 4-year terms, and the 4th district gets appointed or elected 1 year, and then the next district and the next district. So it's a rotating process. And that commission at the time did both the Court of Appeals and the Kansas Supreme Court. Now, because the legislature changed the law, it only does the Kansas Supreme Court. And that's a matter of the Constitution. And that's why this is a constitutional amendment this before us now. What happens if there's a vacancy on the court? That vacancy is announced. And this is an important part of transparency and openness. People apply to be a member of the court. You have to file an application. Your application is public. It's disclosed to everybody. Once the application period passes, then the nominating commission convenes, so to speak. What they do is they identify commissioners to be responsible for following up on the applications, doing some investigation, checking references, evaluating the background, the training, education, experience, the appropriateness of the person for that kind of position. And they then go to a meeting with that knowledge. And depending upon how many candidates, it might be 1 day, it might be 2 days, there's public interviews. And in the interview process, and usually it's 30 minutes per candidate, it depends on how many candidates and all that, they're interviewed, and then the commission, by a majority vote, you have to have a majority vote of all the commissioners, selects 3 people to go to the governor, and then the governor makes the selection.
I just want to make a couple of points here. So first off, these meetings are, not only are they open to the public, they're actually live streamed on YouTube now. So anybody can see the questions that the nominating commission is asking to the applicants.
That's right. I mean, I was a member of the commission during a period of transition. We initially weren't as open, but then we opened it to public sessions for the questioning and all that. And then, of course, maybe because of COVID, certainly because of the need to be more transparent, now it's on YouTube Live and it's archived.
You can sit in your basement at home and scream profanities at the screen as you're watching this.
And so it's and the voting is a matter of public record as well. The only time the nominating commission under the statute was amended this last year, I guess, maybe it was this year. The only time the nominating commission can have an executive session is if it's discussing personal financial kinds of information or official background kind of check information.
There's like a KBI background check involved in this.
But everything else is public, including the deliberations of the commission.
You mentioned the makeup of the commission. So I want to note that it's not the Bar Association that decides who's on the commission, right? It's any licensed attorney gets to vote for this, and it's 1 candidate from each of the 4 congressional districts and a 5th attorney that's at large for the state.
That's correct. And they've altered the procedure there. It's not just every licensed attorney. You actually have to, on your registration, mark a check that you want to be an eligible voter for it. But it's basically the licensed attorneys have an opportunity to vote. And I will tell you about the makeup of those lawyers. I mean, there's some people think, well, the lawyers are all united in interest and they're all have bias and all that. No, that's not the way lawyers work.
You guys argue for a living.
Yeah, And so there is no lawyer block voting here. At least that certainly wasn't my experience. And the lay people are also coming in with, I think, you start out with a governor appointing and the governor changes, so the appointments change over time. I have been, this is an insight into the process that I observed in my 8 years. We did not have a partisan position. The folks on the commission, and I think it's true today, were committed to a merit selection basis. And I will tell you about a transition because I think it's important. I was on the commission first when Governor Sebelius was the governor, then Governor Brownback came in, and Governor Brownback appointed lay people with a different perspective, perhaps. I mean, they were certainly more conservative, and they came in with a little bit of a jaded view about what's going on here.
They were skeptical about whether this is just a bunch of liberals putting liberals on the court.
Absolutely. You know what? They were won over to the process. Because as they sat there and they started watching how the process worked and they saw how the deliberations went and the things we discussed and the things we considered, they realized, hey, this is about getting good people. And the process worked.
This is a process that resulted in a conservative getting on the Supreme Court.
Right. I mean,
Caleb Stegall was...
I was on the commission at the time, and everybody was afraid that Caleb Stegall couldn't get through this liberal nominating commission. Well, you know what? He was well qualified. And the commission knew he was well qualified. And that was one of the standards. Qualifications was important. And so we put his name up. And Carol will vouch for, he's a good Supreme Court justice. So, I mean, that's why I reject the notion that it's a partisan or a jaded process. I just can't accept that at all.
I want to come back to you, Mr. Johnson. So we've gotten the historical look and how this commission works, but why are we here tonight? Why is this amendment actually on the ballot? Can you speak to the political machinery of this?
Yeah, I would say from my perspective, and these are all observations or conversations I've had, you have members of the legislature who are frustrated with the boundaries of the Constitution. When they don't fully fund schools and the Supreme Court makes the right decision and points it out, they get frustrated with that. And you've seen that several times over the years if you've looked at those headlines. Members of the legislature have been frustrated with Kansas coming out in August of 2024 and saying what they did not want when it came to abortion rights. And so you see, if you listen to those and you look at, different headlines, you'll see our current attorney general, some of our candidates for governor, all highlighting if this goes through, they'll get the types of judges that will rule on their side, not necessarily for the Constitution. And again, when I say what's at risk when it comes to justice for all, that's not justice. That's just getting one side's view through instead of, again, following the Constitution. And this is their effort, again, to try to change the way something happens to get around that. And you can see it. I mean, it's in different media sources. You can see our attorney general saying those things. You see those comments from members of the legislature after the session, after not funding schools in the appropriate way. The frustration points to the Supreme Court, and now you have these different efforts to change processes rather than just doing their job. So those are some of the reasons that you see this coming before you now. And again, they get the rulings that they want, subverts the Constitution, they're happy, and most of us suffer. And I think you'll continue to see that. I think I know what side's going to win in this election, and the process will probably stay the same, and then you'll see the legislature trying more different things. Again, not listening to the people of Kansas. So for me, and again, what I've seen, you also can see it. And if you go listen to some of these town halls, you'll hear the same thing. It's folks trying to get around the Constitution as it is. And I think the Constitution's a good document. And again, they get frustrated with justices that are doing their job, following the law. They call them activist judges. They're not. They're just following the law. So I guess if that's being an activist, many people are activists then. If you believe in law, if you believe in following the law, then I think you can see what the motivation is in this process.
Yeah. In 2022, after the vote to defeat the amendments that would have overturned the right to abortion, the future Attorney General at that time, Chris Kobach, said, the answer here is to change the way justices are put on the court. So he made it clear then. We also saw Senate President Ty Masterson in December at a meeting in Marion where our friend Eric Meyer, the publisher of the Marion County Record, reported, Masterson was saying very explicitly to them that the reason we need this amendment is because this is how you overturn the ruling on abortion and on school finance issues. But when you talk to people, in the community or just when you're discussing this issue with anyone, do you think people are connecting what we're voting on this August with abortion or school finance?
I think that message is targeted to the people who care about that, and it's connecting with them because they don't know all the information about this process and how much work goes into just finding good people to do the job. And if you listen to too much of that activist judge thing, and again, there's a lot of money in those messages, you may believe that, but when you go back and look at the actual laws, the Constitution, and you see that the justices are following that, it's different. So it's tough. You have to have these types of information conversations for people to see that. I mean, I've even seen folks saying that they want to vote yes because they don't agree with the death penalty. And if you really care about that, then you should talk to the legislature and tell them to do their job and, get the Constitution changed to ban the death penalty. And then you don't need to change the election process for the Supreme Court because it's in the Constitution that you can't do it. But I think some of those messages are getting to different people who don't know the rest of the process, and they'll go follow that message to the ballot box, it's always tough.
Yeah. Justice Beier, I wonder if you can help us demystify this process of what it means to be an applicant for the Supreme Court, the conversations you have with the nominating commission, and then maybe put us in the room with the governor. You're alone with Kathleen Sebelius, and she's trying to get you to expose all of your political views, right?
No, that's not happening. I'm happy to talk about that. And I went through the process twice. As Jay mentioned, I went to the Court of Appeals in 2000, and back then, the Court of Appeals selection process was exactly the same as the one we have now for the Kansas Supreme Court. It was because the Court of Appeals is a creature of statute that the legislature could change the selection method for the Court of Appeals, and we need a constitutional amendment if we're going to make changes in the Supreme Court process. So I went through the process when Governor Graves was in office, and he actually is the one who appointed me to the Court of Appeals, and then it was Governor Sebelius 3.5 years later who appointed me.
For those who don't know, that's a Republican and a Democrat who have selected you.
Right. So I think my existence is partial proof that, just as Jay said, the process as it exists now for the Kansas Supreme Court is a nonpartisan process. First of all, I guess I would elaborate just a little bit on the application itself. When I was a teenager and turned 16, I went out to go find my first job, and I went up and down the mall, what then was Indian Springs and KCK. I'm a Wyandotte County girl, and poked my head in every store and asked if they were hiring. Well, this is a little more elaborate. The applications for the court can run as many as 100 pages. A candidate's application is that extensive and that penetrating. And once those applications get to the commission, then we know who are the candidates. When the deadline passes, we know who the candidates are. The commission publishes a list of the candidates, and they take all comers who want to contribute information about the candidates. And the commissioners, I think Jay will back me up on this, do not necessarily feel bound by even the contours of that maybe 100-page application. They do their own investigation as well. We are in the middle of a process right now, a selection process right now to fill a vacancy that arose this year. Former Chief Justice Marla Luker retired, and we've been in the middle of that process this summer. And I spoke to one of the current commissioners after the meeting in which the commissioners had selected the 3 finalists to send to the governor. She had been assigned a particular candidate to vet, And she said that she interviewed 19 people about that candidate, only 5 of whom were listed on the candidate's application. So some of those folks volunteered themselves to be interviewed because they thought it was important that they had input in the process. Some of them, I think she went out and found. The colleague with all the little colloquialisms said that when he was a candidate for the Supreme Court, his neighbors, he was from Caldwell, America, just south of us down here. You can see Oklahoma from there. And he said that his neighbors came to him and said, "Johnson, what's going on? I had a KBI investigator in my field the other day, wanted to know all about you. I had a feeling they wanted some dirt on you." And he said, "Well, I hope you didn't give it to him." But at any rate, I mean, this is a very extensive process of vetting these individuals. And then if you're fortunate enough to impress those 9 faces staring back at you in your interview and you make it into the 3, you go and you interview with the governor. And the most recent governors, I think, have made a practice of having their staff do a pre-interview. So you may even have 2 interviews during the time when the governor is doing his or her own vetting. In my experience, Governor Graves just interviewed me by himself.
What questions did he ask?
Well, it's interesting. I think he just wanted to get to know me. I mean, by that time, he had a pretty big pile of paper that told him what my kid's first grade teacher thought about me and what my partners thought about me and people on both sides of the partisan aisle who had weighed in. He had quite a bit of information. The way our conversation actually kicked off is I had seen him most recently, actually clapped eyes on him, when he was passing me in the river run. We were both runners. And so I thought it'd be a nice way to start the interview by telling him I was none too happy about that. And we laughed a little bit, of course, and then I told him I had seen that he was with a friend of mine. And it turned out that he and this friend did a lot of charity work together, which led us into a discussion about the value of public service and both of our desire to engage in it, even though the work is not as well compensated as work in the private sector. It has other satisfactions. And I think I told him that I worked more for meaning than for money. So anyway, I think he got to know me. I think that's what my interview with Governor Graves was like. And my interview with Governor Sebelius was largely similar. She did have her general counsel with her when I was interviewed, and he asked a highly technical legal question. I'm not sure he was really that interested in my answer. I think he was mostly impressing his boss. And I thought that it was probably something on which he'd written a law review article during his law school days. So anyway, but I guess I answered it sufficiently. I thought I answered it very wisely, and it turned out okay. But the interviews with the governors really, by that time, I think they're really trying to get to know you as a person. And
did it cross your mind to I need to provide some sort of dog whistle here that says I'm on their side politically? Or
they just were not interested in my politics. I mean, obviously, I was in one party, and one of them appointed a person who was not in their party. So they just never asked. They just didn't ask, and nor did the commissioners. The commissioners also never asked me about my politics or any campaigns I'd ever backed or anything like that.
We did an event like this last week in Topeka with Natalie Haig, who had served on the nominating commission. She was also the chief counsel for Governor Graves. And she told a story about he had selected, I think it was Marla Lukert for the court. And the 2 of them were walking out to the news conference where he was going to announce to the world that he had selected her. And he stopped and he grabbed Natalie and said, "What's her political affiliation?" She said, I don't know. And she had to run back and figure that out before they went out to talk to the public to announce that she was the appointment.
They were likely to be asked. I served with many of my colleagues for many years. And on the day I retired, I still did not know what party some of them belonged to. It just didn't come up. It's not important. We're going to talk about that, what's important and what's not when you decide.
Well, and the other interesting thing from the panel last week, former Governor John Carlin was there, and he said, I don't know anything about the law. I was like a 4-H kid from Western Kansas, but, I could tell if somebody was a good person or not. And that's what he was trying to get out of those interviews.
That's nice to hear. So my impression was correct.
I want to talk to you, Jay, about being on the commission, how you were vetting the people and the questions you were asking. Did you read the full 100 pages of each applicant that they turned in?
We read the full 100 pages. Yes, we did.
You didn't like divide that up among the 9 members. You read 2, you read 2, you read 2. Each of you read all 19.
We did both, because what we did is everybody would read everything for sure, but then we would assign a commissioner or 2 commissioners to go out and do the follow-up. And so there you would go out to other judges, you'd go out to lawyers, and you would, and you, not just the people who letters of recommendation, because you know what they're going to say. You're more interested in digging deeper, and so we did all of that. And then the interviews and really some of the pre-work too is designed to get at what is this person's judicial temperament? What would it be? What's their diligence? What's their character? I mean, do they have good ethics? Those kinds of things. And if you're a judge, by the way, the commission gets to see the judicial disciplinary records. There's a judicial qualifications commission that takes complaints about judges, and we get to see those kind of complaints. And the bar, there's a disciplinary administrator, there's ethics issues that are recorded by them. We get to see that information. And so, but we evaluate that kind of information. But when we're asking questions is, judges have to work hard, and judges may not get paid all that well for the work so you have to have a passion for that job. And we want to know if those people who are applying have the temperament, have the desire to do the work, and have the ability to do the work. So we'll look at their writing. There'll always be a writing sample, and in some cases there'll be published writing samples if it's a Court of Appeal judge. Or we'll look at that to say, does this person connect the dots and make logical, do they have a logical analysis of what they're doing? Because that's important, because again, you're going to the rule of law, and the rule of law is you're going to fairly and impartially consider the facts that are presented, and then you're going to apply the law to the situation, and then you're going to explain how you did it. I mean, that's the work of art that a judge does. And so we look at all of those kinds of things. And one of the things I want to emphasize, the notion of judicial temperament that we look for. Judges need to have some compassion, and judges need to be able to sit and listen to the parties' cases, whether you're a trial judge or an appellate judge. In order to add validity, if you will, the legitimacy to the system, parties have to go to court and understand that they were heard, that the judge paid attention, and even if they lost, they understood why. And so we're looking for people that can have that skill set. And that's those questions we ask during the interview are designed to get at those kinds of things.
Councilman Johnson, we hear from these two about what it's like to go through this process and get on the court. But I think a lot of people who've had interactions with the justice system have probably had negative interactions. Do you think people understand what it takes to be on the court, or how do you bridge this gap for people who are skeptical of the justice system to understand why this is a process that they should be interested in preserving?
Yeah, that's a great question. I think the answer is twofold. There's a lot of distrust of the justice system. Some of that is because of decisions that have been made, but also just a lack of information of how it all works. And our democracy, our community is better with having these types of conversations about process and actual law in general. Some of that distrust comes to government. I always highlight, we were doing some housing work on the city council, and people didn't understand there was state statute that stopped us from doing some of the things we wanted to do, but we got the blame for it. But once you could break that down to folks and help them to understand this statute stops us, but this is what we can do, then there's more, okay, I get it. Let me focus more here. Let me work with you on that. In this situation, talking about this process, understanding that the goal is to appoint good people and that partisanship is not a factor at the moment. And The more people can hear that or see that or get on YouTube, I think it helps out. But you also have the folks like the person I said that I saw was frustrated with the death penalty. They don't seem to understand how all of that works. And so it's always harder to explain the process to people. It's easy to say, yeah, go vote for somebody. Yeah, you get that power. It's more difficult to break down what's actually happening now, why that's a bad thing, what they want to do, and why this is a good thing, and all the checks and balances in there, and the makeup of these committees, and the different views. And for some people, I relate it. It's a different process, but we make appointments as council members. I don't ask anybody's political party. And just like what the governor did with justice, I just asked questions about that person, what they cared about, what is their vision for the community, why they wanted to serve. And if you seem like a good person that cared, even if I disagreed with you, I'd appoint you. We talk about what I disagreed with, but that wasn't something I was trying to force you to do or do my bidding. And I think if people understood that this process really is seeking good people who will follow the law, who have a great track record, high integrity, good folks, I think that helps out. But again, it's a lot of conversations that have to happen to get to that point. And that's a tough thing. When you're at a door, you get a flyer, your flyer may look good, you read it real quick, maybe you might toss it. I don't get a chance to talk to you for an hour about why this is a good thing. And you might even tune out if you're cooking or something. So it's always harder to talk about the process and the right thing.
I was going to say, do you have any advice for folks about how to go initiate these conversations? Because I think most people will be informed primarily through TV ads, mailers, things that people leave on their doorknob.
Yeah, I would highlight, the one thing I always say is when you see the vote yes and you have a right to vote, I bring up you do vote. You get the vote to retain. So if you don't like decisions being made or opinions by one judge, don't vote for them. And tell your friends not to vote for them, just like you do with any other political office. You don't have to do that to get them in office. When they get into that seat, again, there's a different process, and you have people of high integrity and high qualification that get put there, and it's up to you to retain them. Again, a regular election, you never know what influences are going to be in there. National politics get involved in that, and you don't really always get to see the quality type of person. They may say 5 bullet points, it sounds good to you. Great, and they may not know anything they're doing.
Yeah.
Sherman, can we talk a little bit about who's really going to hold the power?
Sure.
If we have statewide elections?
Tell us.
Okay, good. Well, I just think we need to be realistic and grown up. I mean, we know how elections work. And a statewide election, $1 million is a gross underestimate of what we're talking about.
There are $1 million buys in the primary race for governor right now. In a general election for a Supreme Court spot, there would presumably be much more than that.
Right, exactly. And I'm going to give you an example. This is not something we know particularly from Kansas experience with electing judges, because that was a long time ago before these kinds of numbers were required. These kinds of dollars were required to win a statewide race. But in 2020, I think it was 2025, there was one seat available that was open on the Wisconsin Supreme Court. And they have statewide elections ostensibly nonpartisan, but really nonpartisan in name only, because the Republicans chose somebody they wanted in and the Democrats chose somebody they wanted in. And in that one election, for one seat, more than $100 million was spent to influence the electorate. So it may sound like statewide elections give people, Kansans, the power, but the people who will really be empowered are billionaires, in-state and out-of-state, who have plenty of money to spend to influence elections, because that's what it takes to win a statewide election. I know here in Sedgwick County, you elect your judges, and you're happy with that process. There hasn't been any recent, I don't think, agitation to change it. Our district courts are about half and half, merit selection and partisan election. A person who's running in Sedgwick County can crisscross Sedgwick County innumerable times between declaring candidacy and the election, and not spend very much even on gas. You know, they can buy a few yard signs. They can make sure that all their lawyer friends are advising their friends and neighbors and family members who to vote for in the election. That is just not possible in Kansas. So I want to emphasize that point, and I want to emphasize one other point, if I may.
Sure.
The job of a Kansas Supreme Court justice, I'm happy to talk ad nauseum on this, but I won't. The job is way more than full-time. We're not talking about the slick 40 hours a week and then going home to that family.
Can you recall a particularly long day or long week that you spent?
They all were. I mean, really, we talk about it. Some of the senior justices and I have talked about it. You know, we're talking about 60 and 70-hour weeks. Now, there was some limited ability to control my calendar that I didn't enjoy when I was in private practice. There were other good things about being a judge versus private practice, but they were long days, long weekends preparing for court, etc. Lots and lots and lots of work. I don't know when I would have had time. I can't imagine having done my job at the level I expected of myself to do the job when I had to raise money and campaign statewide. I heard one of the candidates in this year's, one of the partisan races, that's the statewide race, I heard him the other day say that he had spent 6 hours that day on the telephone dialing for dollars. 6 hours that wouldn't be spent working on a case, on an opinion, showing my work, as Jay describes. We say we have to show our work when we decide a case, or doing an administrative task, or speaking to the public about the work of the court. All of that would have to be put aside so that the justices could be candidates who could prevail in an election.
You know, in the lead up to this, you sent me an email with some of your thoughts. You know, speaking of working hard, it was a detailed, long email. But one of the points you made is talking about the distinction between the work of a justice and the work of a politician. Can you elaborate on that?
Yeah, I'm happy to. I think it's really important to understand, and this really goes to the public education piece. I mean, our side of this issue in August is just harder to explain, but this is one of the central points that you need to be able to explain it to your friends and neighbors and family members. Judges who are going to decide a case, Kansas Supreme Court justices, they have access to briefs written by the lawyers for the parties. They have access to the record. Sometimes the record is a few pages, sometimes the record is 50 boxes of what's happened in the lower courts. They have oral argument on the cases, and they take those tools in and they conference together, all 7 of them, to decide the case. But when that time comes, after all the briefs have been read, after the record's been reviewed, after oral argument has been heard, after we've had an opportunity to ask the parties questions and get answers, at that point, when we enter that room, we think about 3 things, and Jay enumerated some of them. We look at the facts as demonstrated to exist by admissible evidence. We look at the legal issues as framed by the parties and their counsel. And we look at the governing law, the potentially applicable governing law. That's it. That's it. Those are the 3 things that can be considered, and only those 3 things. If I'm a legislator or an executive, I have a whole different set, a whole different constellation of considerations. We all know this. We all know this. We expect partisan actors in the political branches, in the representative branches. They put the representative in representative government. We expect them, I think we have a right to demand that they consider constituent preferences and desires, that they look at their party platform, and that they behave consistently with the values of themselves that they have told us about on the campaign trail. None of those things, I mentioned none of those things when I talked about what a justice considers. A justice is prohibited from considering those kinds of things. So they're totally different jobs. And I think because of that, they merit different selection methods.
I think you made a succinct point in the email that the politician starts with a result in mind, and a justice is looking at the evidence before reaching that result. Did you ever have a case where the decision you reached was at odds with your personal opinions about something?
Constantly. It wasn't just, so I talked about the considerations differ, right? You have one branch of government, the judiciary, that is not designed to be representative. It's designed to serve the law. It has one client, the rule of law. So you have these different considerations, but you also move in a different direction. You move in a different direction to the decision, to the action that you're going to take. If I'm on the bench, if I'm a judge, I look at those three things and I go where they lead me, even if it's personally distasteful, as it often was. I don't think I had a single docket where I didn't have to cast a vote or two or three or more, where I would have preferred personally a different outcome. But my job was to look at those three things and go where they led me. If you are a representative in the legislative or the executive branch, if you're a person who's been elected by your constituents to represent them, you have policy outcomes that you seek. You have policy outcomes that you seek, and your constituents vote for you because they seek the same policy outcomes. But you start with the outcome you want to get to, and you go backwards. You go the other way. What path is going to get me there? Okay, so justices start with the building blocks, if you will, and go where they lead. Policy actors, policy builders in the legislative and the executive branches reason the opposite direction. So it's not only a different set of considerations, it's also the direction of your mind as you reach a decision point or an action that you must take.
Mr. Fowler, we talked earlier about this transition where suddenly half of the nominating commission was made up of appointees from Governor Brownback. And I wanted to talk about this a little further and talk more about Caleb Stegall, his appointment. What do you recall about that process and the questions that you guys were asking him? Did it ever cross your mind that we need to be careful about who this is or what he believes?
I don't think it did in that context. I mean, people knew who Caleb Stegall was, and the press was writing stories, and I mean, so you know,
he had been Brownback's chief of counsel before,
right? And so we were all cognizant of that, it wasn't a political decision.
Do you remember the kinds of questions you were asking him or other candidates at that time?
Well, we were asking basically the same set of questions. The way the process works is, and I've been on the Supreme Court Nominating Commission. I was also on a municipal court nominating commission for the city of Wichita for a couple of sessions too. But some commissions have very set questions, and so the same candidates get asked the same questions. And in the nominating commission at the Supreme Court level, when I was on it, it wasn't quite that, but it was very similar. And so you would ask questions about, you know, a favorite question of mine was, because I want to test how they respond to ethical situations. So I would ask a question about, as a judge or as a lawyer, practicing lawyer, were you ever confronted with an ethical problem that you had to deal with, a serious ethical problem you had to deal with, or just a case problem or a challenge that you had to deal with that was uncomfortable, and how you did it? And you wanted to see their thought process. I mean, that was and so we would ask questions like that. The questions now Justice Stegall were not, are you going to vote for one way or another? That never went into all of our thought processes. And if you know Justice Stegall, I mean, very sharp academically, very diligent person, also very collegial. I mean, he ticked off a lot of boxes, and he got through the process because he was qualified. And so that's what we were looking for.
Did it surprise anybody? Like, wow, we're really going with the governor's former chief counsel?
I did get a call from a former Democratic county chair about, what are you guys doing? And well, we're vetting qualified candidates. that was the response. But
Well, I think we should say too on the court, I don't think he's exactly been predictable. He's led a charge for a number of issues that I think people would not have expected after being on the court,
well, see, that's
and has been retained by voters.
right. The point is, though, that if you are working hard and you're deciding cases based on the law and you explain why it's based on the law and the facts in the case, you've got a pretty good position to defend yourself with. And that's what I see with our Supreme Court. Going back to one of the things that Carol mentioned on elections and things like that, I want to make 2 points. First, if Carol Beier's on the bench as Supreme Court Justice and she's going to have to run in a contested election, where's she going to get the millions of dollars? And
Not at my house.
yeah, and that raises the question about if you're getting $1 million from a billionaire or whoever it is, a special interest group, it's going to create at least an appearance of potential bias, and that's a problem. And then the other thing I want to mention, because you mentioned that we have an election system in Sedgwick County. There are 12 district judges up for election this year. There's one contested election, and that contested election is for an open position. I put it to you that the district court in Sedgwick County is an entirely different world than the Supreme Court. In our county, the judges tend to get reelected if they're doing their job, unless there's some kind of scandal or there's some demonstrated lack of judicial temperament, and then they start to draw opposition. But if the judges are doing their job, they get retained. In this case, they get retained by a partisan election. But that is not the world the Supreme Court would be in at all, because there would be partisan contested elections with lots of money. And that's, in my view, a real risk to the integrity of the court.
So, Councilman, we've talked about the impact, what's potentially at stake for abortion rulings and public schools, but the court makes a lot of rulings on civil rights issues as well, from First Amendment to voting rights. The list goes on. I'm just curious if you see whether the stakes are higher for marginalized communities in Kansas.
Oh, absolutely. And I think when you see the president getting involved with things as he has, I mean, that's what's at risk here in Kansas. The types of things he endorses, the people that he endorses who believe in those things, you see the push against anything that has to do with the differences that we all have, whether it's race or sexuality, gender, anything that makes us different, in my eyes, makes us unique and awesome. He's against. And I think that he and other big money would be involved in that. And I think they would look for judges that kind of fall along the same line. And that's where your big money would go. And again, would these people be following the law, or would they just insert their opinions and find ways to get the law to work out their way and then push that to the Supreme Court and waste more of our tax dollars on defending bad positions like we see now? So I think that's definitely a huge risk. And you even see, I mean, just issues within the state now when municipalities try to do the right thing for their people. And you've got attorney general sometimes getting involved or threats towards that. And, we just want to serve good people. So again, changing this process adds in a lot of bad influence, in my opinion. And I think you'll get people that are actual activists against the will of Kansas more so than what we want to see.
I have one last quick question for Justice Beier before we open it up for questions from the crowd. If you had had to run for election, would you have tried to be on the Supreme Court?
I think the last time we chatted about this, I told you that I was trying to figure out that answer. And there was a time when I was still practicing here in Sedgwick County where I was interested in a district judge seat and a trial bench seat. And obviously I knew then that if I got the seat, that I would need to stand for election, potentially with an opponent in a partisan race. And I was prepared to do that. I just don't think so. I just don't think I would have sought the position. because to me, the methodology of selection is so inconsistent with what I described to you a moment ago about what the job entails.
Would you feel beholden to the people who are giving you money?
Well, I think you couldn't help but feel a lot of pressure. I just don't think you could help but feel a lot of pressure. And I like to think that every justice would be able to resist it. Certainly, I think most would try, but I think it's unrealistic. I mean, if you're an otherwise fairly undistinguished lawyer, I hate to say that almost because it's hard to say that any of us are undistinguished, but you know, some of us are just sort of regular, run-of-the-mill lawyers.
We see Representative Carmichael here. I think she's speaking.
Who are, well, I mean, they're just folks who, you know, you wouldn't think, oh, there's some Supreme Court material right there, you know. But if they have good hair and gleaming teeth, and they have a billionaire who's willing to support them, they could be your next justice. And I'm not confident that that person wouldn't feel beholden to the people who wrote the big checks.
We want to give all of you a chance to ask some questions to our panelists here. The folks at Appleseed will bring some mics around. Don't try to take it from them. They won't let you have it. Oh, do you need to take this one?
Yes, I'll take that.
Okay, she'll take my mic.
Sorry.
Is there the negative aspects of elections for the 18th judicial district in Sedgwick County?
What are the negative aspects?
Yeah,
Go ahead, Jay.
you mentioned that.
Well, I'm not saying there's negative at all. What I'm saying is that the system is, the world that Sedgwick County judges are elected in is different than with the world that would apply to Supreme Court elections. I mean, I think merit-based selection for district judges is a good thing too, but in our Sedgwick County District Court, the elected system seems to work. And so we are electing judges. Most of them are good judges. And if there's been a problem with the judge, the election system has taken care of it. But they're not races that involve hundreds and thousands of dollars or millions of dollars. I mean, a district judge might run a race for $25,000 or $50,000 or something of that nature. I mean, they're entirely different character. And so I don't want to say that you need to have a merit-based system for your district judges here because our system seems to have worked. But you can't take that argument and apply it to a statewide race, which is an entirely different character. And that's the point I would make. So I'm not saying it's negative.
I apologize if this has already been answered. I was tardy to be part of it. I'm wondering, there's a rumor going around that the person who is running for the Supreme Court doesn't even have to be a lawyer. Is this true?
I don't think so. There are some very minimal, and they really are very minimal qualifications for to be a candidate for the court. You need to be admitted to practice in Kansas. That seems fair. You need to have 10 years either of private practice or teaching as a law professor or being a judge on a lower court. And you need to be 30 years old. I can't even imagine how you get 10 years of practice in if you're not already 30. But anyway, maybe they're in another dimension. Anyway, so you have this very basic minimal qualifications. But I do want to say a couple of things about scenarios that could occur. I mean, these are not made up horror stories. These are imaginable scenarios if we go to statewide elections. I said 10 years of practice. I didn't say 10 years in Kansas. So it is conceivable that someone practices the bulk of their 10 years elsewhere, but they have a sugar daddy or sugar mama who wants to put them on the bench in Kansas. They could move in and commence running with all that money. So that's one scenario that I want to point out. And I want to point out one other thing. Jay was careful to describe that on the Supreme Court Nominating Commission, we have representatives, both lay and lawyers, from all 4 congressional districts. That geographic diversity is so important. It's so helpful. When I was on the court, Marla Lukert was from Goodland, and I was from Wyandotte County. You know, Lawton Nuss was from Flina. We had Lee from Caldwell. I mean, we had statewide representation on the court, largely because the Supreme Court Nominating Commission takes care to see that the governor gets some geographic diversity. If the main component of getting elected to the Kansas Supreme Court is dollars, and I think those of us who are grown-ups in the room have to admit that that's likely, why wouldn't we have 7 justices from Johnson County? That's where a lot of the money is, right? Maybe 1 from Wichita, you know, but are those little towns going to have representation on the court? Anyway, hope that answered your question.
I love our Republican founding model, but a part of that is federalism. And I know in the 1800s, a lot of states decided to counter the elitism and went to popular elections. And I have just 2 quick clarifying questions. And then one bigger one that was inspired by one of the drafters of this, what we're going to be voting on, spoke at Pachyderm recently. The clarifying is that at the end of the day, the triple play isn't about electing justices, it's about how we fill vacancies, which the legislature will ultimately decide. No, or is that going to be said? They have to clarify it in the language, is like one of the things I'm bringing up.
I'm so glad you asked the question. May I address that first?
Yes.
Okay, great. One of the things that I think we really need to appreciate about the amendment is that there are lots of unanswered questions. I mean, it says statewide elections. It doesn't even specifically say partisan. Remember I said Wisconsin is nominally nonpartisan? But it doesn't even say partisan versus nonpartisan. There are so many open issues, and I believe the language out of the amendment that you'll see on your ballots is as provided by law or whatever, will be provided by law. Well, that means the legislature is going to choose. At some point, they'll fill in the blanks. At some point, they'll fill in the blanks. And that includes what happens with the vacancy. It includes the partisan, nonpartisan question. On the partisan, nonpartisan question, I think we can make a reasonable deduction, an almost unavoidable deduction, and that is this. Currently, Kansas Supreme Court justices cannot do anything partisan other than vote. That's really it. They vote. They can't support another candidate. They can't really even campaign for themselves other than say, yeah, I wrote that opinion. Read it. This is what it says. I mean, there's very, very, very limited ability of any sitting Kansas Supreme Court justice to engage in partisan conduct. The amendment is very careful to say all of that would go away. And justices could even be party officers. And they could raise money directly, et cetera, et cetera. To me, it's kind of unusual to put that in there if you're not intending to go partisan. So that's why I say it's reasonable deduction, but it's not stated. Many things are, we'll decide later. That includes the position numbers that will be assigned to various sitting justices that will control which years they are up for election. That's obviously subject to some fiddling. You had some other questions.
By the
yeah,
way,
Jay,
Carol,
go ahead.
did you know that under the current constitutional amendment and statute for the nominating commission, that nominating commissioners cannot be a party officer?
Oh, no, I actually didn't know that about the nominating commission.
I mean, you could be a member of a party, but you cannot be a party officer.
I think that gentleman had another question or two in there. I saw a hand or two.
Continuing the discussion, but on this point relevant, because I brought up to the drafter about like the Ohio model, Michigan model, as you said, what is specifically going on. But the other thing I brought up is why couldn't we meet in the middle and be something more like the Colorado model? Because I understand why Kansans would not want 5 attorneys and 4 appointees by the governor to be in charge of this process. And I asked, why couldn't we have a process that's merit-based, where it's non-attorney majority, and you have a balance of like a governor appointment, Senate majority, Senate minority, House majority, House minority, and maybe bipartisan lawyers from
different
districts.
states do it differently.
They said they would actually want that, and that would be preferable, but the legislature would not support that, including the Democrats, in being able to put that out on the ballot.
That's interesting.
That was the answer.
Well, yeah, I mean, I don't think really any of us are saying that the current system is absolutely 100% perfect all the time. It probably isn't. I mean, no system is absolutely 100% perfect all the time, but it's certainly far preferable to the alternative being offered now. And there are tweaks that could be made. I don't think it's absolutely necessary that lawyers be the majority. I mean, that's what Kansans chose in the 50s, and if we still think that's a good idea, great. I think we need some lawyers, because let's face it, we don't go to our plumber for heart surgery. We don't. I mean, and I wouldn't go to my heart surgeon for plumbing, So, I mean, there's some expertise that lawyers bring to the table that's needed, that's necessary, really, to evaluate the candidates, to contribute to the discussion. But there are tweaks that could happen that could improve upon what we have. There's no question, and other states have different models for merit selection that could be considered. But that is not what's before you on August 4th.
We're going to go with this gentleman here and then this woman back here.
So this brought to a book that I read several years ago. That was a fiction book, but it was still brought up this basic thing: is the appeal by John Ritter. Someone's read that? Yeah. A small Mississippi town wins a massive verdict against a chemical company that poisoned their water. The corporation has a ruthless plan: buy a seat on the state Supreme Court to overturn the verdict. Justice is about to go to the highest bidder.
Yeah, that's something not too different from that happened in West Virginia.
Yeah.
There was a coal company.
I recognize it's fiction, but it's.
Yeah, it's not too far off, though. I mean, there was a pretty notorious case out of West Virginia. Yeah, that involved a coal company and a candidate for the court who, with the coal company's assistance, got a seat and voted their way. There was a
Hi, my question really has more to do with the retention elections. I'm finding it hard to find information compared to, say, 10 years ago. Do you have recommendations for where to go to find out about the judges?
I sure do. And I want to tell you there's a reason you have less than you used to. I'm looking at Gloria Flengy back here in the audience. She helped run the Cadillac commissions that we had to do judicial evaluations. During my lifetime on the court, this shifted over time. There was a period of time when the legislature funded a truly Cadillac judicial evaluation program. And I mean, they didn't just talk to lawyers about judges. They talked to people who were litigants. They talked to people who worked in the court system. They talked to jurors, etc. And it evaluated all the judges across the state, and they had the judges self-evaluate. I found that enormously useful to me as a judge, to sit down and critically examine how I was doing my job. And we had this great system, but it cost some money. And some folks who don't like merit selection, took them a little while, but they figured out that if we had a Cadillac judicial evaluation system that voters could consult on whether they should retain someone, that was assisting in the perpetuation of merit selection. So, big surprise, the money went away. So that went away. Gloria helped to do a substitute for that for a while. That was great. Wasn't quite at that Cadillac level because we didn't have any money to do it, but she and a bunch of volunteers did some great evaluations for a while. But by and large, they weren't always available after that. Johnson County has always done evaluations for their judges, and the KBA now has evaluations for folks who will appear on your retention ballot. So you can go. This is a place where the Kansas Bar Association is directly involved in making sure there's some evaluation materials out there for voters to consult. So you can go to the Kansas Bar Association website and you can look up evaluation results for judges. Those evaluations are happening right now, and those results will be published before you have to vote in those retention elections. So that'll help.
I'm so impressed with this system as you have explained it to me, to all of us. And I wonder if there was a model for this, or if this just came together. Obviously, it's still being changed because
different states do slightly different ways of doing it. Yeah, it was, I regret to inform you, it's called the Missouri Plan. They were the first, and I think it was 1940 that they adopted a merit selection because they too had a scandal that involved the way that their partisan elections were run and appointments and that sort of thing. So anyway, they came up with it, and we were one of the many states that adopted it afterward.
I wonder if you had any comments on or ideas on how we could prevent another, there was a judge in Marion County that allowed for the raid on the Marion County Register. And how could we prevent that? That seemed like a scandal to me.
You thought it was a no-brainer on the decision? Yeah, well, to be honest, I don't know. We have about half and half judicial districts that have merit selection, and then the other half are like Sedgwick County where they have partisan elections, and I'm not sure what Marion is, whether that's a partisan election. Do you know?
Yeah.
Oh, great.
Yeah. Sorry. That was a magistrate that signed the search warrant. There was a complaint filed with the commission that handles complaints against judges, and I think, from my perspective, and as a journalist and for the public benefit, I would like to see those commissions and also the Ethics Commission for attorneys opened to the public so that we could see how those commissions were making their decision. That commission decided that even though she signed a unconstitutional warrant that was based on flimsy evidence, that she did not violate any ethics, anything that would warrant discipline for her. I would just like to know what evidence she provided to the commission, what deliberations they had to reach their conclusion. I think opening that up would go a long way for folks to understand, why these decisions are being made.
Yeah. And to make a call in the next retention election or partisan election on that judge. Yeah. Yeah. There's one.
We have one more question. Unfortunately, he was right here. So sorry.
Thank you all for your comments tonight and your information. Justice, you identified 3 distinct things you look at when you make a judicial decision.
Right.
And you beautifully delineated that. Thank you. Don't ask me to repeat them. My question is, what would prevent an elected justice from using those same three criteria?
I don't think anything would prevent it, but I think there'd be even more pressure than is already there to conform to perceived public opinion, or worse, the desires of the big donor. That's the piece. You just don't want corruption of the process I described. It's hard enough to vote the opposite of my desire as a justice, as a human being, as a family member. I mean, if a child, for example, is a victim of terrible crime, but the defendant didn't get a fair trial, that's a hard vote to cast, right? So I just think you don't want to add to the pressure on justices to deviate from those things.
I think I would add briefly to that. As an elected, when we run for campaigns, you don't always know truly the type of person we are. You see it in pictures, you may hear it in conversations, but you don't know what happens like under pressure with that person. Like, will they ethically do the right thing? And so someone may say they'll do those three things, but if you've got some mega donor or someone calling, not happy with that decision or trying to influence you, you have to truly trust that the character of that person that received all those millions of dollars that got in there will actually do the right thing and not what's being told. And I've only had it happen twice where somebody who gave me some money was like, hey, I really would love for you to do this. And when I voted against them, they got upset about it. But not everybody does that. I've watched elected officials at various levels cave under like the smallest of pressures. So that's one thing that I would not want to see on a Supreme Court justice. And that's one thing that's tough for everyone to see. We all portray strength in our campaigns and all of that, but true strength is when you're under pressure and nobody's watching. Are you going to do the right thing, or are you going to do what's easy? Maybe upset the people who voted for you, but you got millions coming back in and you'll stay in that seat. And some people, unfortunately, will buckle to that. So you'd have to trust in the situation that these justices in this new system wouldn't do that. And I don't trust that.
Well, with that, I would love to thank our panelists and to Sherman Smith